even though the topic is foreign documents before Croatian courts, of course, it's not only the courts that deal with use of foreign documents in Croatia, but this was just to simplify the title. Instead of giving the overview of the content at the beginning, what I wanted to do is to show some main characteristics of the entry or use of foreign documents in Croatia. Unlike like in every other state and like in any other private international law area, there is a combination of sources today. So we basically have a jungle of sources, both domestic ones, international, and European ones. And this is also true for use of foreign public documents, not only in Croatia, but elsewhere, as we've seen so far as well. But when it comes to main characteristics in specific areas that I will cover today and that reflect the paper that I and we have written, well, basically, legalization does come as a rule. So in order for a foreign document to be used in Croatia, it does have to be legalized. However, exceptions do exist, primarily if a treaty, bilateral or multilateral one, is enforced, or in case when no reciprocity, where reciprocity on lack of legalization exists. When it comes to recognition of foreign judgments, basically, again, recognition is a rule in either independent deliberation proceedings or incidental recognition for the purposes of that proceedings only. So no automatic recognition is exists in Croatia outside of international treaties or European sources. Again, sworn translations are a rule with some exceptions, such as in case of undoubtful content of the document presented by the parties. And finally, when it comes to excerpts from civil status records, basically they are treated in the same manner as any other public document. So to go into more details with the legalization, which is maybe the crux of the whole research project, we have a combination of our domestic act, which is a legalization of foreign documents in International Legal Transactions Act. It's a fairly old piece of legislation that we have basically copy-pasted from former Yugoslavia once we gained independence. Of course, we are a party to the Hague Apostille Convention and some other multilateral treaties that abolish legalization, but will not be mentioned today. They are mentioned in the paper as well. And there is a number of bilateral treaties, the same thing we have also witnessed from the Polish and Slovakian perspective. So as I said, the domestic piece of legislation is actually a very old one from the 70s, and it's now being planned to be modernized. Actually, the legislative plan of our Ministry of Justice states it will be issued or at least proposed by the end of this year. The main goals being modernization, together with digitalization and issuance of e-apostilles. Legalization under that act is a requirement unless there is an international treaty abolishing it or replacing it, or if our documents need not be legalized in the country of origin of the foreign document. This reciprocity can also be a factual one, meaning that if the foreign courts do not in practice or other bodies do not in practice ask for legalization, we can do the same. If no exact exceptions exist, so-called full legalization is required, basically the one combining of the internal in the foreign country and then international in the sense the consular one, or with the action of our Ministry of Foreign Affairs as well. The issue whether the document is a public one or not at all is to be decided by the law of origin of the document. It is true that I have found cases in which the courts err in discerning whether the document is a public one or not by applying Croatian law, but the rule is more or less clear. I mean, not more or less, it's very clear, and the theory is also on the same foot when it comes to applicability of the foreign law to discern whether it's a public document or not. On the other side, the probative value of such documents is decided by Lex Fori in accordance with our Civil Procedure Act, which in Article 231 equates the value of foreign public documents with domestic ones, of course, under the requirement of legalization or exceptions to it. This means that they hold a presumption of veracity, quite similar to what we have heard in Slovakian report already. There is a number of bilateral treaties that basically abolish legalization, so they don't have a substitute procedure, but abolish legalization completely. There is a number of them. I won't read them out loud. You can see them on the slide. They, however, do differ with respect to coverage, both substantive one, in the sense whether they cover civil and commercial matters, or only or also administrative matters. But also they sometimes differ with respect to what documents they cover. Sometimes they only cover civil status excerpts. Sometimes they cover only judicial documents. We cannot really have, so to say, a general conclusion on those issues because the differences are rather wide, so to say. Last but not least, we are, of course, a party to the Hague Apostille Convention. We have been so since independence, and it seems that no particular problems arise with respect to the coverage, to the practice in issuing apostilles and accepting them. However, there was one problem that occurred with apostillization of e-documents stemming from abroad, because our bodies were sometimes rejecting those apostilles given the fact that some sections, such as issuer, signee, were issued as were marked as not available, given the fact that the e-documents were apostilled. However, our Ministry of Justice has issued a recommendation to accept such apostilles, and it seems that the issue has been resolved. As I said at the beginning, e-apostille is not yet available in Croatia, but hopefully soon enough, by a revision of the Act, it will also become possible. This leads me to the issue of recognition of form and substance of foreign documents. And strangely enough, there is no general conflict of laws rule in our Private International Law Act dealing with the form of legal acts. Our Private International Law Act is a rather new one from 2019, so it has been revised after we became a member state, and this revision was long overdue, since up to that date, the old version of the act was in force. That was again copy-pasted from former Yugoslavian legislation. The former act had an alternative connection, so either Lex Causa or Lex Loci Actus, which is also something widely accepted. And the new one does not actually provide for any general conflict of laws rule for that particular issue, given the fact that the idea behind the new act is to widen the scope of European sources as much as possible. We apply, for example, Rome I and Rome II to issues that have been excluded from their substantive scope of application. So we don't have any specific rules dealing with either contractual or non-contractual issues. We are party to the Hague Form of Wills Convention, so that resolves that issue. We are also part of the twin regulations dealing with matrimonial regime and the regime of registered partnerships. So basically, the legislator found no need to include a general conflict of laws rules for form. The bilateral treaties, some of them at least, do still contain such rules, which are basically the same as the old version with respect to alternative connection, even though Lex Reisite does appear as relevant for acts dealing with real estate. On the other hand, when it comes to recognition of substance, of course, there is a variety of conflict of laws rules dealing with different issues, but there is no specificities with respect to, for example, immovable property, which is usually something that might be formed as an exception. Of course, the lex recita rule applies to all proprietary issues, but no specificities exist either there or with respect to power of attorney. Again, strangely enough, our law has never had a specific rule on the law applicable to the power of attorney, and there seem to be no cases available. I mean, there are no cases available, which does not necessarily mean that there are no cases at all in Croatia, just given the fact that only a portion of them is published. And the theory is rather scarce on that issue as well. We have one seminal work, a doctoral thesis, but again from 1990s, that dealt with that issue and suggested application of optio juris as the first step, if accepted by the third party, and in lack of such a solution, the representative seat would be applied. Again, this is a suggestion in theory that has neither been accepted or rejected in practice. This leads me to the issue of recognition of foreign judgments, which basically from the outset has accepted a limited control system, meaning that only based on a very limited number of reasons a foreign judgment can be refused its recognition. And those reasons are not unknown of the jurisdictional issues, of course, public policy, right to be heard, res judicata, so nothing particular there. However, the recognition proceedings need to take place either incidentally or as in independent proceedings. And unfortunately, the bilateral treaties do not alleviate really those prerequisites. They more or less just state them again in more or less similar or same manner. There is an interesting point here, however, that pertains to legalization. Based on a situation we were in a few years ago that happened with adoptions outside of the Hague Adoption Convention, the question arose on the issue whether foreign judgments need to be legalized before the recognition proceedings. What happened is, I mean, outside of the scope of this presentation, but there was a scandal involving our adopters that wanted to adopt from Democratic Republic of Congo, and they were retained in Zambia and went through criminal prosecution. However, it seemed that after that scandal, it was discovered that there is a number of children adopted from Africa and Croatia, and that in some cases judgments were legalized and in other they were not legalized before recognition took place. That urged our legislator to add a new rule in our Private International Law Act dealing with legalization. But in a way that it's formulated now, it's still unclear whether the legalization obligation pertains only to adoption decisions or should be accepted more generally. This latter solution was already adopted in legal writings beforehand. But the new rule might have left some doubt as to this prerequisite. Last but not least is the issue of translations and civil status excerpts. Well, basically, our Civil Procedure Act is rather clear that the translation needs to be done by a sworn translator in order for it to be used in civil proceedings. The same goes for land registry proceedings, so the inscription of any immovable rights on immovables. Still, if the content of the document presented is not disputed between the parties, the translation is not even necessary, and the case law even shows that. However, on the other hand, if the translation is just an unofficial one, the court will not take it into account if there is a dispute as to the content. Interestingly enough, our Administrative Procedure Act states that the sworn translation is only necessary if the authenticity of the translation is doubted by the body dealing with it. So the rules are more relaxed when compared to the civil procedure ones. Coming to the last section, the last issue I wanted to talk about today is the civil status excerpts. Basically, they do present, they are treated as any other public document in the Republic of Croatia. What is important is that foreign civil status excerpts can be basis for inscription of facts concerning our citizens that happened abroad, such as marriage, death, and birth. However, again, legalization is a requirement, but we are party to two important CA conventions, the one of 56 and 76, dealing with the latter one dealing with multilingual extracts. So in the end, this leads me to a conclusion that even though Croatian system is fairly rigid, I would say, because any document entering it, which is a public one, needs to go through some kind of authentication. It does not pose severe problems in practice. So the problems are bureaucratic ones, because it takes money and time to go through the legalization or certification process, unless the exceptions exist. But all in all, it doesn't seem that our system, as it's framed today, poses significant hurdles for the parties. This leads me to the end of the presentation, and I'm thankful for your attention, and will be glad to answer any questions you might have at the end of the panel.